All right, welcome in everyone to another deep dive.
Absolutely.
Where we're unpacking some really significant legal decisions. And today we are looking at the case of Knick v. Township of Scott, Pennsylvania.
Right.
This case had some pretty huge consequences for property owners across the U.S.
Absolutely.
It really gets to the heart of when you as a property owner can go to federal court if you believe a local ordinance or a local government is violating your rights under the takings clause.
Yeah. So essentially, this case kind of flipped the script on a previous Supreme Court ruling. And it's got some pretty big implications for how property rights are handled between individuals and local governments.
So to set the stage here, the court initially ruled against Knick, but then upon rehearing, they actually switched and sided with her. So what they basically did was overrule a really long-standing precedent. That came from the case of Williamson County v. Hamilton Bank. And that precedent said that if you believe your property's been taken, you actually have to go through state court first to try to get compensation. And only if you're not satisfied there can you go to federal court.
Exactly.
So in this deep dive, we're going to explore why the court decided to change its mind and also what this means for property owners like you and for local governments across the country.
Okay. So, you know, to really understand the Knick decision, we have to go back and look at how things worked before. So the key here is that Williamson County precedent. And the important thing for you to remember about Williamson County is this thing called the state litigation requirement. So basically, if you as a property owner felt that the local government had taken your property, you couldn't just run straight to federal court.
Interesting.
You had to go through
all
all the potential remedies that were available to you through the state court system. So you had to kind of exhaust all your options at the state level first.
So even if it's a federal constitutional question, you still had to go to state court first.
Right. And that's what makes this case really interesting. Is it's this interplay between state and federal courts and when you can bring your claim. Where
Interesting.
So only after the state courts had made their final decision and you were still feeling like you hadn't gotten justice, could you potentially then file a takings claim in federal court.
So this was kind of the system that had been in place for a while.
Exactly. And this had been the law of the land for, several decades.
All right. So let's get to the specifics of the Knick case then. We've got Rosemary Knick, who owned some property in Township of Scott, Pennsylvania.
That's right.
And the township had passed an ordinance that said all property owners have to allow public access to any grave sites on their property.
So imagine you're Ms. Knick.
Could see why she might not like that.
You have this property and suddenly people can just walk across your property to get to a grave site that may or may not even be marked. It's a pretty big imposition.
So she sued the township.
That she did.
And her argument was pretty straightforward. She's saying, look, this ordinance by requiring this public access is a taking of my property.
That's right.
And she says, I'm not being justly compensated for this as the Fifth Amendment guarantees.
And that's a key point, right? Is that the Fifth Amendment says you can't have your property taken for public use without just compensation. So she's arguing that this ordinance is essentially taking her property without giving her just compensation.
And so her legal argument really focuses on the takings clause. And what it means. And she's saying that the moment this ordinance was passed, it immediately took away one of my rights as a property owner.
Which is the right to exclude others from your property.
And she says because of that, I should have access to federal court now. I shouldn't have to go through the state courts.
Correct.
Now, it's the Township of Scott, as you might imagine.
As you can imagine, they disagreed.
Saw things a little differently.
They did.
They said, no. You have to follow the Williamson County precedent, which means you got to go through our state process.
That's right. You got to go through
inverse condemnation.
Inverse condemnation, which is essentially a legal claim that you can bring as a property owner when the government takes your property.
Right.
But they haven't officially condemned it.
Yeah.
They haven't gone through the eminent domain process.
So they're kind of saying there's no constitutional violation.
Right. There's no violation until
the state fails to provide compensation.
The state has failed to give you a way to get that just compensation.
So they're saying go through our state process.
Right.
And then if you're not happy, then you can go to federal court.
That's their argument.
Now, what's interesting here...
Yes, this is where it gets even more interesting.
...is that the federal government actually got involved.
They did.
In this case.
They filed what's called an amicus curiae brief.
Okay.
Which is basically a friend of the court brief.
Yeah.
And the Solicitor General, who represents the federal government in the Supreme Court, actually argued in support of Mrs. Knick.
Wow.
Yeah. So they're saying...
So that's pretty rare.
Yeah, it's not unheard of.
Yeah.
But it definitely signals that the federal government thought this was an important issue.
An important case.
They basically said, look, if you're a property owner and you're raising a question about a violation of your federal constitutional rights, you should be able to go to federal court to get that resolved.
You shouldn't have to go through this other process.
Right. And they argued that the Williamson County rule had essentially closed the doors of the federal courts to people like you who are claiming that their property had been taken.
So they're saying that rule is actually hurting people.
They're saying it's creating an unfair barrier to justice.
So that's really fascinating that the federal government's
and it shows you
taking that position.
How high the stakes were in this case.
Okay, so that brings us to oral arguments in front of the Supreme Court.
Yeah.
And this is where you really get to see...
Yeah, you get to see how
the justices are thinking about this.
The justices are grappling with these issues.
So one interesting moment was when Justice Breyer brought up a hypothetical. He's saying, imagine you have a state environmental agency that passes a regulation that affects lots of property owners.
Right.
So his question was, how do you decide who is entitled to compensation among all of these property owners? And should they all be able to...
And should they all be able to just...
Run to federal court?
Run to federal court without going through the state process.
And it seems like he's concerned about overwhelming.
Right. He's worried about a floodgates problem.
Yeah.
You know, if we overturn Williamson County, are we going to just have tons and tons of takings cases all going into federal court?
And so that's a valid concern.
It's a legitimate concern.
Right. But then on the other hand, you have Chief Justice Roberts, who seemed to question how often states actually...
Yeah, he's kind of pushing back on
provide
this assumption that states are always going to provide just compensation.
Right.
It's kind of like, well, how often does that really happen?
Right.
You know, we're making people go through this state process.
Yeah.
But is it really protecting their rights?
Yeah.
So he seemed a little skeptical of that state litigation requirement.
And then Justice Kagan jumped in.
Justice Kagan,
And she zeroed in on some real problems with forcing property owners to go to state court first.
She had both theoretical and practical concerns.
And one big concern she had was these preclusion rules that came from a case called San Remo Hotel.
Right. And preclusion is a really complicated area of law.
Yeah.
But basically what it means is that if you litigate a claim in one court, you might be barred from bringing that same claim in another court.
So the worry there was that.
Right. So the worry here is that
if you go through this whole process in state court,
yeah,
and then you want to go to federal court,
you might be precluded.
You might be told you can't even bring that claim. Yeah. And so that seemed like a major problem.
Yeah. And this was something that a lot of legal experts had pointed out as a real flaw in the Williamson County rule.
So then Justice Alito asked a very pointed question. He's like, why are we treating takings cases?
Yeah. Why are these takings cases
differently from other constitutional claims?
Treated differently than other constitutional claims.
When it comes to having to go to state court first, it's like you're saying.
He's basically pointing out
what is this?
An inconsistency in how the court has been approaching this.
Treated so differently.
Right.
And then we have Justice Kavanaugh, who I think it was really interesting. He was kind of exploring
I was looking at alternatives to just overturning Williamson County.
Yeah.
So he was thinking about, could there be other legal bases for federal jurisdiction in these cases without completely getting rid of Williamson County? And so he was kind of saying...
Right. And he was also expressing concerns about how state courts might handle federal constitutional rights.
So he's really thinking about it.
He was really thinking carefully.
In a lot of different angles.
About all the implications of this decision.
Now, Justice Sotomayor, I think, made a very interesting comparison.
Yeah.
She compared the usual requirement that you have to go through a federal administrative process.
Right. Like if you have a claim against the federal government.
Before you can go to federal court.
You often have to go through an administrative agency first.
And she's saying, why is that different?
And she's like,
from this state court requirement in takings cases.
Why is that different than having to go through state court for a takings claim?
If we make people go through this administrative process at the federal level, why shouldn't we make them?
Why are we treating state courts differently? Go through the state process.
Than federal agencies.
Yeah.
It's a good question.
And then finally, Justice Gorsuch.
Yeah, Justice Gorsuch.
I think he just kind of put it very bluntly.
He cut to the chase.
He said, look.
He's like, look.
Preventing a federal takings claim until you go through the state process.
Until you've exhausted state remedies.
Sounds a lot like an exhaustion requirement.
It's an exhaustion requirement.
And he's like, that's not how we usually handle.
He's like, and that's not how
constitutional claims.
We usually do things with constitutional claims.
Right.
You know, you don't normally have to go through a whole other court system before you can bring your claim.
Okay, so we've got all these different
all these different perspectives.
Arguments, perspective, all these different ideas.
And the court ultimately decides.
And in the end,
to overturn Williamson County.
They overturn Williamson County.
So what was their main reasoning for doing that?
So their main reasoning was that
the Fifth Amendment's takings clause actually protects a right to just compensation the moment your property is taken.
Right, at that moment.
They said, you don't have to wait for the state to fail to compensate you.
Right.
You have that right from the get-go.
Yeah.
And they said, this right is immediately enforceable in federal court.
Okay. So
you can go straight to federal court.
Right away.
If you believe your property's been taken.
Right.
And they said, this Williamson County rule that was making you go to state court first was an unnecessary burden on that.
Yeah.
It was essentially blocking your access to federal court.
So what changed?
So what this means for property owners,
like the property owners as a result of this decision,
is that you can now bring your federal takings claims directly to federal court.
Straight to federal court.
You don't have to go to state court first.
You don't have to exhaust.
You don't have to go through
any state remedies.
Yeah, that whole rigmarole.
And so this has the potential to speed things up.
It could potentially streamline the process.
Yeah.
Make it much more efficient.
Yeah.
For property owners.
And it also addresses that preclusion concern that Justice Kagan brought up.
It avoids that risk of, you're barred from bringing your claim.
Yeah, you get stuck in state court.
In federal court.
And you never get to actually argue your federal claim.
Exactly.
So now I want to step into that hypothetical 10th chair.
Okay.
As a justice on the Supreme Court.
All right.
I have to say, I think the court got this one right.
Yeah.
I think overturning Williamson County.
I think it was the right decision.
Was the correct decision.
Yeah.
And the reason is...
I agree with you.
When you look at the Fifth Amendment and how it's written...
The text of the Fifth Amendment...
Yeah.
It seems pretty clear to me.
Seems pretty clear.
That you have a right to just compensation the moment your property is taken.
Yeah.
The moment the taking happens.
Not after you go through some state court process. Not after you've jumped through all these hoops.
Not after you spent... years and thousands of dollars.
It's like right then and there.
Right.
You have that.
And requiring people to go through this state court process before they can even assert their federal right
just seemed
like a huge unnecessary burden.
Yeah, it just seems backwards.
It seems backward.
And like Justice Kagan pointed out.
Yeah. And that risk of preclusion.
There's a real risk.
It was a big concern.
Yet your federal claims could just get swallowed up.
Exactly.
In state court.
You could lose your right.
And you never get a chance to have them heard.
Have your day in federal court.
In federal court.
On the federal claim.
Now, I understand that some people might be worried.
Yeah, there are concerns.
That, oh no, the federal courts are going to be flooded.
Federal courts being overwhelmed.
With all these takings cases now. But to me, property rights are just so fundamental.
Property rights are fundamental.
That you need to have that access to federal court.
You need that federal forum to vindicate those rights.
So I'm glad the court...
And I think this decision ultimately leads to greater accountability for local governments.
Right.
Because now they know that if they take your property, you can go straight to federal court.
Called into federal court.
And you can have your claim heard.
And that should lead to...
And that hopefully will lead to
more consistent application.
More consistent protection.
Of federal takings law.
Of your property rights.
Across the country. Across the board.
And it gives you a more efficient way.
Yeah, it gives you a more direct path.
To protect those rights.
To justice.
So I think it's a win.
So I think overall it's a positive development.
Okay, so that was our deep dive.
All right.
Into Knick v. Township of Scott.
A really fascinating case. Yeah. With some pretty huge implications.
Huge implications for property owners.
For property owners.
Local governments.
Local governments.
And our judicial system as a whole.
Absolutely.
So as you're thinking about...
So as you're listening to this.
And what it means for you.
And thinking about your own communities.
I want you to think about...
how this might affect...
your own property rights.
Your own property rights.
Your interactions with local government.
Your interactions with local governments.
What questions does this raise for you?
Yeah, what questions does this raise for you?
About how your property rights are protected.
I got the future of property rights.
And what challenges do you think?
And what kind of challenges?
Might come up in the courts.
As a result of this decision.
As a result of this shift in the law.
I think it's going to be really interesting.
Yeah, this is definitely an area to watch.
How this plays out.
In the coming years.
Thank you for joining us.
Thanks for joining us.
On this deep dive.
On this deep dive.
We look forward to exploring...
We're looking forward...
more fascinating legal topics with you.
To diving into more cases.
In future discussions.
With you in the future.
See you then.
See you then.